Of Andhra Chamber of Commerce, I welcome all the members and distinguished guests to this webinar on incorporation of a proper and effective dispute resolution clause in every business agreement. I would like to welcome Mr. Moksha Kalyanram Abhiramula, Honorary Advisor of the Company Law Matters and Intellectual Property Rights of Andhra Chamber of Commerce, Secunderabad. As you may be aware, dispute resolution or dispute settlement is the process of resolving disputes between parties. The legal system provides resolutions for many different types of disputes. Some disputes will not reach agreement through a collaborative process. Some disputes need the coercive power of the state to enforce a resolution. Perhaps more importantly, many people want a professional advocate when they become involved in a dispute. Particularly in the dispute involves perceived legal rights, legal wrongdoing, or threat of legal action against them. In this program, we are going to see how this dispute resolution has become important and must in a business agreement. To discuss and understand about the importance of dispute resolution in business, we have with us today Mr. Abhiramula, Honorary Advisor of Company Law Matters and Intellectual Property Rights of Andhra Chamber of Commerce, Secunderabad. Thank you, Mr. Kalyanram Garu, for accepting our invitation to present a very important topic today. I'm sure that this session would be useful to the business people present here. I once again welcome the participants to this program. Thank you.
Thank you, ma'am. Thank you for the brief introduction. And I now invite Mr. V.D.S. Koteshwar Rao, Executive Committee Member and Honorary Advisor Foreign Trade and DGFT Customs, to please introduce the speaker.
Thank you, madam, for giving this opportunity. Now, good afternoon, everybody. This is Koteshwar Rao. I would like to introduce Mr. Moksha Kalyanram, who is the main speaker of this today's program. Mr. Moksha Kalyanram Abhiramula is a practicing advocate, specialized in corporate laws, tax laws, financial laws. He is also a chartered accountant, cost accountant, company secretary, and MA and MPhil economics from Madurai Kamaraj University. He has presented various papers on tax matters, intellectual properties, and other issues like white collar crimes. He has over 19 years of experience in BSFI, intellectual property rights, healthcare, infrastructure, and education management. He is a partner for Law Mintage Legal, Law Mintage Consulting LLP, Law Mintage Brand Values LLP. So he is also a very active member with various institutions and organizations, and is an active member and life member also, like Andhra Chamber, FAPSI, Hyderabad Management Association, TAI, etc. So I have pleasure in presenting my friend Mr. Moksha Kalyanram. So I request Kalyanram to proceed with the presentation.
Thank you, sir.
Thank you, Koteshwar Garu.
Welcome.
It is always a pleasure to hear from you. Your work makes inspiration, sir. Now, can any organization be away from dispute? Howsoever we do our business activities, primary thing that we never want things to happen is a dispute with our client, a dispute with our vendor, or dispute with any business counterpart which we do business with. But fortunately or unfortunately, or sometimes situations drive in such a way that a dispute arises. Now, whenever a dispute arises, first thing that comes to any person is how to solve it. But before that, what documentation is required is what we are discussing. See, every time what happens in a business activity, it's a post-mortem exercise. Once a dispute happens, then we try to find documents, find where the invoices are, find where the payments are. Today, there are courts which have said that WhatsApp conversations also can be taken as evidence. Still, there are plus and minus discussions going on. Someone says, I have made a telephone recording when I have asked money to the client. Is that recording acceptable in the court of law? So a number of things come into play. But what, as a businessman, we need to understand is best course of action is always to have a business agreement with every stakeholder whom we meet. It could be a vendor, it could be a supplier, it could be a customer, it could be a third party vendor to us, it could be anyone. In fact, we'll be surprising whenever we try to go for a bank and say, I want to open my account, we sign a form. But classically, we are not signing a form, we are actually signing an agreement with the bank stating that you are going to have a fiduciary relationship with me. When we speak to this with a regular business people and MSME segment more specific, they ignore this particular point. They are not much concerned about documentation. They feel this is not of that important. But the point is, when something really goes wrong, people fall upon as to what exactly they started as their original discussion. So what we are trying to present right now is, first, what should be a business agreement? What are the contents of the business agreement? What is the significance of a dispute resolution clause? No one wants a dispute to come. But if it comes, then how that has to be handled? If that is in the agreement itself, it saves a lot of time, energy, and so on. Else, when we take a legal advice and the notice is sent from us to the opposite party, that becomes a starting point of the entire case. When we have an agreement, now the case starts from the agreement itself, and the counsel can advise or write a notice better than what an imaginary missing link connection would be. Now let's try to see, why do we need a business agreement? Any company, it's not a small entity, it's not a big entity, any company, a company which has started today. Now, what do you exactly mean by company which started today must focus on it is any contract which we enter into, which should have 4 conditions mandatorily complied with. The first condition is ascertainment of rights. What are the rights we have as a service provider or a goods provider, and what are the rights the receiver has? Could be a consumer or could be the vendor or whatever, who is the other party to that particular business agreement. First thing what we have to do is ascertain the rights. Second, what are the responsibilities? Who is responsible for what and to what extent they are responsible? Third, LOI stands for something called line of interest. When I'm writing an agreement, first I need to know what is my business requirement. What are my possibilities which I would negotiate or discuss with my other counterpart. If my other counterpart is unaware of the line of interest, then we'll come up with an agreement which actually is against us when something goes wrong. So we should always have line of interest first written, meaning what do I want in layman terms? Forget about the legality. In business parlance, what do you want as an outcome of this business transaction? This comes as line of interest. We don't need a legal knowledge for it. We need a business knowledge for it to understand what is line of interest. Line of interest is done by the party. Agreement is made by the person who has legal knowledge. Need not be an advocate, but an advocate makes an agreement. The probability that the agreement is comprehensive is high. That's where we talk about an agreement coming up. Now, the last important thing is clear exit options. Sometimes business becomes obsolete. Take a classic example where a new model of mobile phone has come into the market. Dealer who has a stock of old mobile phone must have an exit option, something like a replacement option. The old dealer, whatever stock is available of the previous model, which becomes obsolete, must have a fallback or withdrawal. We have seen many a times where cars are launched by car making companies. They get complaints. So once a complaint comes, if you actually see Honda had complaints on its BRV version and CRV version. First CRV was withdrawn. Then BRV was withdrawn. Now the only thing in SUV version that is running is WRV. Now, when you say withdrawn, what happens to the dealer who already has stock with it? So there should be some exit option for that particular stock. That must be part of the business agreement. This advocates or legal knowledge people will not know because they are not in the business. Businessman knows what exit options can come, how the stock has to be treated, what is the perishable nature of that particular stock. So businessmen would talk about line of interest, exit options, responsibilities, rights. This is written by us who is running the business. Now, once we are clear about these four aspects, then comes the next nature of evaluation. These are the key areas for any business agreement to come. Whatever are rights and responsibilities are reshuffled in law as obligations. By and large, responsibilities will come as obligations, and line of interest will be studied in something called inclusivity and exclusivity. What should come as a part of agreement? What will be out of the agreement? We will be coming under the second key area. Third key area we talk about is dispute resolution. How a dispute resolution can be framed. Now, out of these three, dispute resolution is something which pure legal language it is written. Parties obligations is business as well as legal language. LOA is again a rephrase of the business language to legal language. Now, this is the statistics. I wrote here business entities. The reason why I wrote business entities is it could be a proprietary concern, it could be a partnership firm, it could be any business entity, a firm, an LLP, an AOP, a BOI, an individual, a company, all come under business entities. So we are not bifurcating here who needs a business agreement. Everyone needs it. Now, how many of them spend time? If we take Indian statistics, it's phenomenal. We have in crores business entities. Like close to about 60 to 70 crores of business entities are there, including firms, proprietary concerns, and companies. Out of that, only 38% have business agreements with them. The reason why they have 38% is also because they have some legal counsel on board, then they start writing agreements, or else everything is whatever comes to them, they sign off. Now, what's a party obligation? First party obligation is product or service. Focus is on quality. The obligation of both the parties is quality of this particular product as well as service. Second obligation. Now, what is this? Is basically as agreed in the agreement. Second is consideration. It's the value agreed for. It could be paid in installments. It could be paid in lump sum, whatever it is. Then the deadlines. When is the delivery expected to happen? Now, this is how we have 8 points which we'll be discussing for a business agreement outline. The first point, the first 4 characters are displayed right here. Any business agreement will start with parties' details. Now, here is the catch. People sometimes don't capture that information which is important. What is not captured is mobile number and email ID. And this has to be updated whenever there is a change in the mobile numbers. When a legal notice is sent to the email ID gets bounced back. This is what we have seen in practice. First job is to get this information as a part of the agreement. Second, we have to keep checking with the client whether there is any change in the mobile number or any updation of the email ID. Some email IDs are missing. We have to keep this information. But fundamentally, your agreement must contain complete name of the party. Here, if we are signing off with a company, what is complete name for us? Complete name for us will be the company name as well as a representative name. We'll discuss when we talk about party details in totality. Matter of the contract. As per the business agreement, what is the subject matter? Is it into selling of goods and services? Or is it into selling of any particular product? We'll talk about what is in the subject matter comes full detail here. What is primary? It's what actually you have signed for. Allied activities can be, initially you may have signed for a software agreement. Later on, you might have signed for networking agreement also. Initially, you have ordered for a product. Later on, you may have upgraded it with a package. So package becomes allied activity, product becomes primary subject matter. Now, what are the obligations? A comprehensive list is required. Spend time, write maximum obligations that hits your mind. Obligations are not exhaustive, but they are all something we call as inclusive. If something similar comes in, that also comes under obligation. For a classic example, a building is given on lease. Now, when the building is given on lease, any furnishings within that particular building must be approved if it is a permanent fixture. If it is not a permanent fixture, approval is not required. Now, this will be a part of that particular agreement. If nothing is mentioned, then again, it's a point of discussion or an argument whether it was approved or not. So obligations must be as exhaustive as possible, but then it's never exhaustive. Consideration. This should be a separate, distinct, identifiable clause as to whether invoice would be raised or a running invoice would be raised or payment would be given on account, including the payment terms. Everything must come under consideration. So our first 4 blankets will be parties details, subject matter, obligations of the parties, consideration. Now let's see the next 4. This is something which hardly we've seen in agreements to be written. We don't see risk and cost to be mentioned. When you don't mention anything on risk and cost, presumption is you have accepted every risk on the earth with that business transaction, which is dangerous. And if you don't limit the cost, it becomes an unlimited liability that comes out of this business agreement. And cost also must be pondered upon, evaluated, and written. Now, there are something called inherent risks, explicit risks. We'll discuss further when we get into that particular clause. When will this agreement be terminated? Never there is a perpetual agreement. We have partnership contracts which are at will, but then always a termination clause. We should have a termination clause for a simple reason that there could be some event which can lead the business obsolete. So we need a termination clause there. Like if you see, COVID-19 has made many hotel leasings obsolete because they felt the operation cost is high and there's no point in continuing the business. So many of them have closed that particular contract. They could do it because of the termination clause. That's what we call as by event. Applicable laws suitable to your business, known to you, include. You can exclude some clauses which are not relevant to you. You can specifically say this act is not relevant to this particular business agreement. And finally, the dispute resolution clause. Now let's see one after the other. This is mandatory. Whenever you say, I am starting to write an agreement or I have started to write an agreement, this list must be with us. The business name, it could be a proprietary concern, but we need the business name, complete address of the business, who is representing the business, and designation. He's a partner or a managing director or a deputy manager or a general manager. Why? The reason is today X is the deputy manager of the company. Tomorrow someone else will become deputy manager. So when you say business name, address, designation, deputy manager, XYZ was there when you filed the contract. Now XYZ is not there. Someone else is in a position. That person becomes a representative of the company. Now let's put it like this. 2018 we filed the case. 2018, Mr. X was the general manager of that particular company. Now in 2020, when the evidence is coming for B has become the general manager. Now you will not go and search for X. You will ask B to come and represent, give the evidence. So the designation is the ruling factor. Identity details. It can be employee code, it can be Aadhaar card, it can be PAN card, whatever it is. How do you identify that person? Mobile number. Preferable what is given by the company, else the personal number. Email ID. always it is suggested, if they are corporate clients, to have an official email ID. Like it's your at Lamentage or at Google. These are official email IDs. At Gmail is a general email ID. It can change. In fact, documents may go haywire. So most preferred is the official email ID. That's where our party details are. We start any agreement with these details. These are mandatory. Now, once we are done with this, second one we'll focus is the subject matter. Now, what is the subject matter involved? Complete description of the business activity must come in the agreement. It should not be objective of business is to run a BPO company. Now, what is a business process outsourcing? It's an ocean. You're processing for banking, you're processing for legal, you're processing for back office, you're processing for documentation. It's not clear. The subject matter must have a complete description of what is the activity, because based on this, your risks and costs are decided. If we don't give a clear picture here, our risks and costs will not match what we described here. So it's a complete comprehensive list which is to be given. In this, we have to again bifurcate into two. What is the primary activity? What is the secondary activity? Now let's take the classic example which we started with as a BPO. We are giving BPO services. Now in this BPO services, we say segment is banking. Primary activity is managing CRM application of savings account. Clear? Or managing CRM database. What could be our secondary activity? Protect the data, storage of the data, safeguard of the data will be a secondary activity. There can be ancillary activities also. Similarly, what else you can do? That comes under your primary and secondary activities. List always must be as exhaustive as possible, because that will decrease or ascertain our risk profile. Now, these are the obligations. Now, when you say obligations, first obligation we talk about explicit distribution of scope of work between the parties. What I exactly mean by explicit distribution is, in our first case, that is in our subject matter at point 2, we said we will have primary activity, we'll have secondary activity. Now, what is important in obligations is, you clearly say who will do which part of the primary activity and to what extent they will be completing that particular work. That's what exactly we mean by explicit distribution of scope of work. You divide the work with complete written documentation that this list of items will be done by party A, the second list of items will be done by party B. Second, if there is any sharing of infrastructure, we will crystal clearly talk about what part of the infrastructure is used for the business agreement. Because generally what happens, if you take example of Tata Group, 2 or 3 companies will be in the same building. When that is so, they say one floor or one part of the infrastructure belongs to so and so part of the group, and this part belongs to the other part of the group. So they have an infrastructure earmarking and infrastructure utility. When that is not there, we will not be able to ascertain the cost and will not know whether the entity is doing profit or not. So particularly infrastructure earmarking becomes mandatory. If there is a shared resource, how are the allocations done? And what is the cost involved? And what are the timelines and deliveries? This comes under obligation clause. We have seen agreements where people also put layout map. Sometimes people also put the workstation numbers also in this shared resources. Agreements must be as elaborate, as comprehensive as possible. That's where our obligations are. Now, this is the consideration. Now, when we talk about consideration, first we talk about total agreement value. Then we also talk about payment structure. We don't expect default to happen. But if it happens, what should be a penalty, if any, we want to charge? Next, the applicable taxes. Is GST applicable? Is any other TDS norms applicable? Or you have to pay any STT involved? All that stuff we come under applicable taxes. Now, one point we need to deliberate here in applicable taxes is we cannot say that this tax is final, because prior to GST scenario in 2016-17, if there were agreements which wrote VAT, not applicable taxes, that agreement would have certain challenges. We won't say it is not valid, it would have certain challenges. But if it has been written applicable taxes, the VAT would have been immediately replaced by GST without any separate amendment. Legislative changes keep happening. That's what we just now discussed. Now we have to always give a room for legislative changes. Sometimes a legislative change may make the business from legality, it will shift to illegal. What do we exactly think is, when Bitcoins came into India, there was a confusion. Bitcoins are valid, Bitcoins are not valid, Bitcoins can be traded, they cannot be traded. RBI gave a circular. Bitcoins are not tradable in India. When there is a confusion, we have a confusion with respect to legality. Now, when it is said it cannot be traded, that becomes illegal. Now, when it is illegal, the business agreement itself gets void. No rights, no responsibilities are derived from that particular agreement. When legally the subject matter becomes a void or legally it becomes illegal, automatically the agreement becomes closed, the agreement becomes withdrawn in totality. Contingencies can be written in your agreements. These are what you presume can happen, but need not happen. Classic way, what we see in contingencies is insurance obligation sometimes is written under contingencies. Sometimes indemnity clauses are written. Indemnity clause we generally see in leasehold properties, where a furnished accommodation is given to a company. That furnished accommodation will also have a clause of indemnity. If by any act of the lessee, the furniture or internal structure of the building is damaged, the lessee will compensate that loss to the lessor. Now, lessee will never cause the damage, but if at all it happens, there is an indemnity clause which comes under contingencies. Now, warranties. Warranty basically is you maintain the service in the way it was promised for. If it is not delivered, we try to invoke warranty clauses and see that it works out. Unexpected liabilities sometimes happen. It's like you have taken a good team of employees. The team is working extremely well. COVID comes. Now, what will you do with the employees who are on bench, whom you don't have any work to? Would you pay 50% or whatsoever? This will come as a internal negotiation at that point of time, because it was not dealt in your agreement. Now you are dealing it. Force majeure clause. Force majeure clause, if we were giving this particular presentation, let's say about 3 years back, it was very difficult to explain a force majeure clause. But now with COVID, it is simple. You say COVID, that's a force majeure clause. Force majeure means you invoke, close the agreement prior to the termination norms or prior to the continuity norms. Because something sea change has happened in the system or the market. When an epidemic comes or when a pandemic comes, the world has never seen it before. So they invoke a force majeure clause and say, look, I'm not continuing the contract, I am closing it. Classic example, what we were used to give a force majeure clause example was when a war breaks out between two countries and a transaction has happened between the same countries. Parties to the contract cannot exercise that particular agreement because the other counterpart has become an alien enemy right now. So that's where a force majeure clause example was given prior to pandemics. Now, for force majeure, everyone gives COVID as an example. Now, this is the termination. First mode of termination of any business agreement is mutual consent. This is simplest, clean, without any pressure route, where both the parties sit, discuss, understand the challenges, come to some conclusion, close the contract. This is first classic style. Second is a default clause. When there is undue delay happening from one party to the other, it is considered as a default, and based on the exercise of default clause, you can terminate the contract. There is a damages clause. Default and damages go hand in hand. Whenever there's a default, it lands to damages. And when these two come, automatically settlement issues come. We can have an exclusive termination clause talking about all these four options. That's the best way of writing an agreement. Now, what's a dispute? Dispute in simple terms is a difference of opinion. Party A says something, party B says something else, and the argument continues. And we don't see any way to solve this particular argument. So a dispute arises from that segment. Now, what disputes can we address? Through a business agreement, the only type of dispute that we can address, be it in dispute resolution mode, or courts can address in a wider range, but generally when we talk about a dispute resolution, we only address commercial disputes. Now, when we say we will address commercial disputes, how they are addressed? The first way they are addressed is the three ways in which we can address a dispute resolution. First way is what we call as mediation. Second is what is called as a conciliation. Third is what is called an arbitration. All these three come under a major head called alternative dispute resolution, wherein we are not approaching the court, we are approaching parties who have the knowledge of doing this particular process, and they bring an amicable solution therein. Let's see one after the other. Now, this is a mediation. Mediation is an interactive process. There's one party who listens, he becomes your voice box. He listens to what party A says, he listens to what party B says. Sometimes notes is prepared, sometimes fights are pacified, and finally, there is a resolution for the conflict that comes up. Now, if you ask me what is the guarantee, answer is there is no guarantee. This is a type or a method to solve the problem. And this is accepted by law. And if the mediation happens by a documented process, this can be shown in your further court proceedings if at all they happen. So mediation done by an official mediator or a mediator who knows the process will be used, the entire document will be used as an evidence in the court. That can be used. We can have an option for it. Second style, conciliation. Slightly better than mediation. Here, the dispute between the parties, in the first case, it's only discussion. Classically, if you see, the person who is sitting as a mediator becomes a voice box. He will not give any opinion. But when it comes to conciliation, conciliator gives opinions, conciliator suggests, conciliator drives for an amicable solution. So in a mediation, maximum advantage what we can expect is a documented process. In a conciliation, more than documentation, there is a suggestion involved, and suggestion is in the best of interest of all the parties. That's where a conciliation is a better settlement option. Further process, the process which has wider legal study, wider legal understanding, and you can use execution proceedings also, is arbitration. Arbitration is a procedure in which the dispute is submitted by agreement. It must be a part of the agreement of the parties to one or more arbitrator, and whatever decision is made by the arbitrator, that becomes final to the dispute. This is otherwise called as an arbitral award. Now, which of three is good? All are good. But if you see the order in which they are supposed to be done, first choice is given to mediation. Mediation fails, it goes to conciliation. Conciliation fails, it goes to arbitration. You can directly jump to arbitration, or you can follow the process of mediation, conciliation, and arbitration. There is no standard rule for the stages, but then once arbitration kicks in, mediation and conciliation automatically is done, or conciliation and arbitration happen simultaneously. Mediation is ignored. Now we'll just have, this is how the process of a resolution clause comes. You talk about mediation first. Then you talk about conciliation. Finally, you talk about arbitration, which is the award. Now, what is more important in the order is ADR selection and order. Key thing is nature of hearings. How are you going to hear the transactions? Is it in written? Is it documented? In which form are these taken care of? Generally, when we see common things in all the dispute resolution clauses is, all hearings are in written format only. It's a common thing which we write whenever we write a dispute resolution clause. And all conversations or all hearings will be in English language only. Because classically, language of high courts and Supreme Court is English. You can give a statement in lower courts or a trial court in the local language, vernacular language. But when it comes to high court, that vernacular language will be in need of an English translation. So if you are making our hearings in English language, it saves a lot of time and the time frame. What part or what stage ends at which time? Now let's see further. In our dispute resolution clause exclusively, this is most important. Time frame for each method. How long a mediation can take? 10 days, 15 days, 40 days, 1 month, 1 year, whatever it is. You can have a time frame for each method. Appointment mode. Who appoints the mediator, or who appoints the conciliator, or who appoints the arbitrator, that can be written. Language of the proceedings. How are the process of hearing and arguments taken? Then web and application seat and venue is what we are going to work out. Now, this is a sample dispute resolution clause which I would be reading out. You can, as it is, pick it up and then add it in your agreements. It is a comprehensive clause. It runs in 3 or 4 slides. The advantage of this dispute resolution clause which I have kept is, you need not make any changes. Pick it up, drop it. But for understanding, we'll have an explanation of what it is. The first paragraph talks about disputes or differences arising out between the parties. Aggrieved party notifies the other. Party who is happy will never talk. Party who is suffering will always talk. So the suffering party will make a list. See, this is the problem. This is the loss I'm incurring. This is the further impact on my business. So we'll talk about the nature of dispute, what was the problem. We'll talk about what is the value involved and why is writing to the other party. We'll talk about what breach was committed. And what is the crux of this particular letter or the notice is we want an amicable solution. Now, the moment we say we want an amicable solution, we are exclusively talking about mediation. We want someone to sit in between, work as a voice box, help both the parties to understand the problem and then solve it. So agreement between the parties is resulting to solution. That's what you exactly mean by amicable solution. What is the mediator doing? He's facilitating. That's it. Mediator generally does not give an opinion. They can, but generally they don't. What is the timeline? You are attempting to reach an amicable solution, that is mediation. You say 30 days is the time. We'll start today. That's 10th of December. We'll see what can happen till 10th of January. If no solution is arrived, let's go to the next level. We can do a conciliation for it, or we can jump to arbitration. Here we're saying the dispute is taken for mediation or arbitration. Any dispute including adjudication of its validity, ratification, amendment, termination, and breach of condition as a whole shall be referred. Now, if all these are failed, then we'll get into conciliation. Now, let's further see where it goes to. A mediator or a conciliator shall be appointed by written consent of both the parties. This is mandatory. Whoever is the mediator appointed by the aggrieved party, the other party must accept that person as a mediator, or mediator is changed. Unbiased mediators will take. But classically, written consent is mandatory. Now, once mediation fails, then we'll go for conciliation. Conciliation here we have said is 90 days. The reason why we have said or is sometimes mediation and conciliation are done together. So the 30 days merges with this 90 days. So the maximum time for a mediation or a conciliation is 90 days. You can have mediation done, spend 30 days, could not solve it, take another 90 days for conciliation, could not solve it, then you take the dispute to the arbitration. Now in all cases, be it mediation, be it conciliation, be it arbitration, we said all arguments and hearings in such processes shall be in English. We can also write only there. And further, an arbitration tribunal is appointed. You'll appoint a sole arbitrator. Again, we have to mention that arguments and hearings will be in English only. We decide something called a seat and a venue. Seat is the place where the jurisdiction comes in. Venue is the place at which you actually do the arbitration process. Now, seat can be Hyderabad, venue can be Banjara Hills, some area. So you specify seat as well as venue to understand the limits or court jurisdictions for executing this particular arbitration agreement. Now, this is where the entire clause is, and this type of clause will help us to understand what process should follow. Whenever the dispute comes, first we'll look for amicable settlement. Doesn't happen, there is some document already created. Then you go for a conciliation. Doesn't happen, document is further advanced. Then you come to arbitration. Past mediation and conciliation proceedings are referred. Solution is trying to give awarded, and of time. It may not come to this extent. What may happen is we may not lead to arbitration at all. Many cases may be solved at mediation level itself. But if there is no clause, if directly you write a clause directly, it has to be arbitrated. Cost is involved. Arbitrator has his own qualification and expertise. So there's a cost there. Mediator can be within the company or a common friend for both the companies. An arbitrator is not a common friend. Arbitrator is alien for both the companies. Arbitrator cannot be a known person to either of the parties. So this will help the process of dispute to get resolved. In case it fails and you lead to arbitration, whatever arbitral award comes, you can directly file an execution proceedings for it, get the money recovered. If the award is a receipt of some money, directly you can file an EP for it, that is execution proceedings, and get the money recovered. You need not wait for a regular recovery proceeding of a court, which classically would take about 3 to 4 years, sometimes 5 years. But if you are using an arbitral route, the entire process will get completed in 1 year. We are saving the time. Instead of a regular court civil proceedings taking for about 3 to 4 years, we are trying to close the same through an arbitral route, including mediation and conciliation for 1.5 years. So we have saved 1.5 years of interest, 1.5 years of sufferings, and business acumen. So that's from me. Any questions? I would be glad to answer.
Yeah, the floor is open for question and answers. Any participants have any questions, please feel free to ask. You can unmute your.
Yeah. This is Siddhi here.
Yes, Dick.
Sir,
You can close this presentation, sir.
Thank you very much enlightening on this wonderful topic, dispute resolution, sir. And I thanks Andhra Chamber of Commerce arranging such a beautiful session for us. My question is, whenever we are dealing with any international counterparties or customer, the dispute resolution I'm keeping in my agreement, but a question comes how it will be treated, what law will be applicable. I try my level best to keep as per the Indian Arbitration Act and resolve the dispute, and other parties might from the UK or some other country. So what you see, sir, how we can resolve the issue?
Whenever there is a cross-border agreement, international commercial arbitration comes into play. Some content of Arbitration Conciliation Act 1996 will be adopted, but then the major content would be governed by international commercial arbitration norms. We have something called arbitration constitution rules, and there are international arbitration constitution rules. So we'll follow those rules and then we'll sort it out. In fact, you can add in your arbitration agreement. So whatever we have given as a dispute resolution clause, you will add one more paragraph to it, talking about what are the applicable laws at that point of time. You cannot say when you're doing business with UK, I'll have applicable laws of India. It's something called equity and equality is missing. So you have to also take their laws and your laws into consideration. You have to mention both the acts. And see, law is not something which is alien. Law follows something called principles of natural justice. What cannot happen naturally, it cannot happen through law also. So that's the basic thing. So you have to see what is the laws applicable in UK, laws applicable in India. You can have a mix of it, write a bigger clause for it, and then that clause would be applicable in your agreement.
Sir, this is Irfan Khan here.
Yes, Irfan Khan.
Actually, I just wanted to check with you. The arbitrator is a governing body by law, or is arbitrator can be someone who has knowledge of the business or the transaction? Who should be the arbitrator?
Arbitrator is not a person who just understands your business. Arbitrator is a person majorly who understands the law. So classically, an advocate can be an arbitrator. Retired judges are common arbitrators. Sometimes, like let's say you have a construction contract where you don't expect an advocate or a retired judge to have knowledge of it, then a person with construction knowledge can be an arbitrator, but you prefer a team there at that time. You'll have, that's the reason I said one or more arbitrator. So when you have a specialized area required, like let's say you have a patent issue. A patent issue is not known to everyone. So you have a patent expert. You have an arbitrator who is either a retired judge or an advocate who is empaneled, and you have other parties involved. Generally, when more than one comes, the number is odd. You will have either 3 or 5 or 7. It's like that. We have seen arbitration tribunals which run at 11 also. 11 members tribunal will be there. Possible.
So this specialized person should be from the industry, right? So we can
Choice
appoint him
of
as
the
an
party.
arbitrator.
No, choice of the parties. If you have a specialized person, it is you who have to choose it. And it must be agreed to both the parties.
Okay.
But if it is a retired judge, he can be appointed by the High Court or District Court. If you want a specialized person, courts will not know. You have to intimate the court that this person knows. This is the reason why I believe he knows. And if other party agrees, then that person will be one among the arbitrator. He will not be the only arbitrator.
So is his decision, decision is binding on the both parties?
Yes. Decision of the arbitration tribunal is binding on both the parties.
No, the whole tribunal is binding, but the person decision is taken by the specialized arbitrator, which is appointed by both the parties.
Once you make a tribunal, it is tribunal's decision. It's no more individual's decision. All the 7 together will decide or vote. If 5 say yes, 2 say no, or 4 say yes, 3 say no, and the 4 saying yes will continue.
Okay.
And if you don't like that particular order, that means you are aggrieved of the order, you can always go to High Court.
Okay. Thank you, sir. Thank you very much for a lovely explanation. Thank you.
My pleasure, Irfan.
Hello, sir. This is Ibrahim from Satwa Logistics.
Yes.
Can arbiter be even numbers? That is one from each party, or odd numbers only you have to appoint?
If it is one from each party, these two will be appointing someone called presiding.
Okay. These two will appoint.
These two will appoint someone called a presiding arbitrator. Presiding arbitrator will be giving a note whenever there is a tie.
Okay. Thank you, sir.
Sir, I have one more question.
Yes, Mr.
To
Shri.
Andhra Chamber, as well as I want your opinion. Can you have told that in a dispute resolution, we have mediation and conciliation. So whether Andhra Chamber of Commerce is providing this mediation or conciliation services, we can add that. Is my contention is correct, sir?
We are in the process of doing that. We are in the process of building up a mediation and conciliation center in all the chapters of Andhra Chambers. President would announce. It's not me who has to announce.
Yes, President. I request.
We are actually, as Mr. Kalyanram said, that we are in the process of building a committee because we have around 16 subcommittees so far. Now we are also planning. The last meeting we have discussed and then decided about the importance of this arbitration and mediation committee, and we wanted to have it, and we will soon have it, and definitely will inform all the members on that.
Yeah, I have a small query, sir.
Thank you.
Yeah.
Yes.
This is Chandrasekhar here.
Yes.
So it's a wonderful session, and the small query is, what is the powers of this arbitrator? Like once they have given the judgment, do they have the power of the court, or do we have to be obligated by the judgment, or it's up to us?
Okay. First of all, a correction. Whatever is given by the arbitrator, it's not called a judgment, it is called an award.
Okay.
Because he is not a judge to give a judgment.
Okay.
So arbitrator gives an award. Now this award basically is in the form of value. So and so is to be paid by so and so person to so and so person. Now this value of arbitral award is final. As I said previously when a question was asked, if you are aggrieved of that particular value, you can go to High Court for set aside. But whatever is the arbitral award is given, that is equal to a civil judge's judgment. So it's a decree given by a civil judge, equates it. So if you are aggrieved of the arbitral award value or the way the award was given, you apply for a set aside in the High Court. So in fact, in a layman terms, we can equate the arbitral award to a decree given for a recovery suit by a judge, by a civil judge.
Okay, so does this arbitrator has to have some qualifications, sir? We can appoint anyone as the arbitrator.
You cannot appoint anyone. No?
Okay.
A judgment, if he should understand the law, he should understand the court process. Classically, if you see a 10 years advocate, a 10 years practicing advocate will be taken as an arbitrator. All retired judges by and large are arbitrators. They are considered to be arbitrators. Some prefer not to, but then generally they become arbitrators.
Okay, so basically from the legal industry, we cannot put the...
You have chartered accountants, you have company secretaries also.
Okay, so we cannot put the industry veterans into this.
Industry you can put, it's not that you cannot put, but he will be a part of arbitral tribunal. He will be one among many.
Oh, okay.
Industry person will not know law.
Okay.
So he needs a person who knows law. So it will be a tribunal.
Okay.
It's not one.
Yeah. Thank you.
Yeah.
Any other questions? I think if there are no questions, can we? Any questions, Mr. J?
Yeah. Good evening, sir.
Please.
J from Chennai. Normally, in one of our cases, we received an award from NCLT. After that, this resolution professional has discouraged to vote for the COC meeting. So whether the resolution professional is deciding authority for this arbitration, or shall we go for a High Court for the further decision?
To my understanding, what you have said is
because one of our case we received an award from NCLT.
okay.
So before that the COC meeting was conducted, and we have rejected for this voting for the COC meeting. So once after receiving the award, the resolution professional is not encouraged that you are not they are not allowing to attend the meeting, COC meeting, due to there is a voting percentage was not there.
So you are one among the COC member?
Yeah.
You can approach the High Court for being aggrieved. In fact, you can also move before the same NCLT bench.
Okay.
Our contest, this is our arbitral award. We applied for the resolution professional's consent to add it in the COC meeting, and resolution professional is not doing it. He is not supposed to do.
Okay.
You being a part of the COC member, he is not supposed to do that. But then sometimes you change. Now, when that happens, you have to move the NCLT bench first. Then you can
Okay.
go.
Fine, sir.
Hello.
Yeah, Mr. Jain?
Yeah, yes, sir.
Is that clear, Mr. Jain?
This is Vinod Kumar.
Yeah.
I have one question, sir. Whether this MSME council, which is there under the Act, is more powerful than what we write it and put a arbitration clause and appoint an arbitrator?
MSME tribunal or council is only for cost management.
Okay.
The arbitration tribunal or the arbitrator whom you are going to appoint, by and large, expected to understand at least 30 to 40% of your problem. MSME tribunal doesn't try to understand the problem. It only tries to see that the recovery comes in. Major requirement of an MSME tribunal is not to resolve other parts of the dispute, but to make the recovery faster. So if you have a recovery issue, you go to MSME tribunal, things move. But in an arbitration tribunal, because they are consented by the parties and appointed by the parties, probability that your dispute would be resolved on a mutually agreed level and benefactor level is high. MSME tribunal will not look into all that.
Okay.
Into what is the value receivable, when was the contract completed, what is the interest, how it has to be paid, pass order. That's all. They are time bound and they are very specific. You say this is the additional clause which you have to study, they are not interested to listen to you. Arbitrator would do.
Okay, but in the case of MSME council, if the party who has been awarded and who got an award, and if the other party who has rejected, if he goes to the lower court against this award, he has to deposit 75% of the payment. Whether this same thing applies here in our arbitration?
Classically, no. But you can file an IA. Whoever is the party who is asking for a set-aside, he can ask for deposit of the amount. But there is no such mandatory clause in Arbitration Act. That is a specification made by MSME Council.
Okay. Okay.
In case of arbitration, you have to put it as an IA.
Okay. We can write it there in the agreement itself in case of a. We can make one of the clauses as that is in case of arbitration.
100% you can make.
Okay.
You can save deposit 90%, then talk.
Okay. Okay. Right, sir. Thank you. Thanks a lot.
Thank you.
Thank you, sir. Any further questions from the participants? So I'll proceed with the formal vote of thanks. So as we all know that conflict can occur in any business arrangement at any point of time, but today we could come to know that how a dispute resolution is so important. And thank you, Mr. Kalyanram, for the excellent presentation. We have already, you have covered very well on the, not only on the dispute resolution, but on the structure of the business agreement and what are the points that we need to have it in mind when we create the business agreement. And thank you for that. And thank you also for explaining in detail about the types of dispute resolution. It was a very, very useful session as far as I know. And even if we are able to understand, even a layman is able to understand about this. Thank you very much, sir. And I thank the president for staying back for the whole session. Thank you, ma'am, for this, for your presence, and it gives always a moral support to all of us. And thank you, Mr. BBSS Kotishwar Rao, for your excellent support. We disturbed you in the last minute. Thank you, sir, for staying back. And thank you, Mr. Ramanjaneyulu and my other teammates who are instrumental in helping me in bringing the participants. And thank you all. And I would like to announce the next session on 16th, that is on the economic impact due to COVID-19. What is going to be the economic impact? And this is the 12th Somayajul lecture that we are organizing on the 16th. And I request all the participants to please, join us for that also. You will get the mail separately from Mr. Ramanjanelu, and you can also get it from the Chennai office through mail and through WhatsApp also. And request all of you to join. Thank you all.
Thank you.